Davis, you may resume your cross-examination.
Thank you, Your Honor.
Yes, sir.
Mr. Walter, it's true, is it not, that at some point in August of 2008, Mr. Preston filed a lawsuit in his capacity as county administrator against you and against Cindy Wilson?
Yes.
The allegations from that lawsuit were that you and Cindy Wilson were interfering with Mr. Preston's ability to do his job as a county administrator.
Yes, that's what he said.
The allegations from that lawsuit were that you and Miss Wilson were running afoul of the Home Rule Act.
Yes.
If you would, about 4 or 5 tabs down, there's a tab that's marked as Plaintiff's 1. Will you turn to that for me?
Minus 1.
Yes, sir.
Right.
This is the Preston Master Employment Agreement that you testified about on direct, is it not?
Yes.
During the summer of 2008, you reviewed this contract, right?
2000, yeah.
Now, on page 1, if you look down at the bottom of the page, there's a section. And it talks about section 4-9-660. Do you see that?
I do.
And if you turn the page, Mr. Walter, at the top of the next page, there's a quote. Do you see that quote?
Yes.
And that quote says, "Except for the purposes of inquiries and investigations, the council shall deal with county officers and employees who are subject to the direction and supervision of the county administrator solely through the administrator, and neither the council nor its members shall give orders or instructions to any such officers or employees." That statute actually appears directly in Mr. Preston's master employment contract, does it not?
Yeah.
While we're here, can I turn your attention also to page 4 of this master employment contract? Do you see way down in the bottom where it says subparagraph E?
E, yeah.
And that paragraph says, and I quote, "Contemporaneously with the delivery of all severance pay and entitlements here and above set out, the administrator agrees to execute and deliver to the county a release, releasing the county of all further claims that the administrator may have against the county," end quote. Right?
What it says.
And this provision appears underneath the termination without cause provision that Mr. Tessier talked to you about on direct examination. Right?
Let me see, what are you saying exactly? Rephrase your question, do you mind?
I don't mind at all, sir. On direct examination, Mr. Tessier asked you questions about the buyout provision in Mr. Preston's master employment agreement. Do you
Right.
remember that?
Yeah.
And that buyout provision actually appears in section 3B, well, a section that says termination without cause, right?
Right.
And what we just looked at was subsection E underneath that provision. And what that provision reflects is the scope of the release that Mr. Preston was required to deliver upon payout of the severance monies. Does it not?
On payment to him, he's supposed to give a release, but that doesn't address the severance agreement itself. So it might be two different things we're looking at.
Well, what I'm asking you about is what paragraph E says. In paragraph
That's
E,
what it says, but I think you might be doing some legal interpretation and manipulation on that point. Because I think that maybe the judge, I've had a question for the judge, whether or not that.
well, let me ask you this. Can we agree that what subparagraph E says is that the administrator will agree to deliver to the county a release? Right? That's what
Yeah,
it
it
says.
says it will.
All right, now let's keep going. Mr. Walter, there came a point in time, did there not, when you became aware that the intent of Eddie Moore, a councilman-elect, was, in fact, to get rid of Joey Preston?
Mr. Davis, I cannot answer that because it's impossible to know the intent of Eddie Moore on everything. It really is. I could surmise, I could speculate, I could do a lot of things, but I cannot tell you exactly what Mr. Moore's intentions were.
Will you turn back to Defense Exhibit 46 for me, sir?
Thank you.
Defense Exhibit 46. Could you turn
46. I've got 45. Oh,
Are you there?
right, yeah,
Defense Exhibit 46 is an email from Eddie Moore, right?
I did.
And it's an email to you.
Yes, I think it is.
And it's dated August 14th of 2008.
Yeah.
And it states in the second sentence, and I quote, "He is desperate and just wants to freeze everything so we can't run him off," end quote.
Right.
And the next sentence says, and I quote, "I find it particularly interesting that you are getting the blame for my idea about suspension of finance director and himself," end quote. That's what he wrote to you, right?
What it said.
That's what he wrote to you, right?
That is what is in Exhibit 46, Mr. Davis. Yes, sir.
Let's keep going. Will you look
Do you have a
at
response?
Defense Exhibit 47 for me, sir?
Excuse me, do you have a response to that?
Mr. Walter, he's not required to respond to your questions.
All right.
You may proceed, Mr. Davis.
Can you look at Defense Exhibit 47 for me, sir? Is Defense Exhibit 47 an email from Eddie Moore?
Yes, sir.
Is it dated September 23rd of 2008.
Yes,
Is it addressed to you?
it is.
Does it reflect that that coming Sunday there would be a meeting with Tom Beckwith?
It says, "Hey Bob, do you have the email addresses for Joey Preston, Gina Humphreys, and Linda Edelman? I want to send one requesting budget copies for us. I also talked with Tom Beckwith and Bob Daniels. That will be there on Sunday." That's what it said.
In September of 2008, sir, it's true, is it not, that you were meeting at your office with Bob Daniels to look at requested budget materials from the county?
I suppose so.
Mr. Walter, can you turn and look at Defense Exhibit number 22 for me? On direct examination, do you recall testifying that Mr. Bright never contacted you to try to ascertain what your opinion was in relation to the Preston matter?
Objection, Your Honor. That's not the testimony. He did say he talked to Tom Bright.
Beg your pardon?
That's not the test. The way he's characterized that testimony is not accurate.
Well, you can explain it. I mean, I'm not trying to say anything. That's what I thought I remembered him saying. If I'm wrong, I'm wrong. I'm not trying to
I'll allow him to
mislead.
respond, and he can either admit or deny whether he made those statements. You may proceed, Mr. Walker.
Any question is?
It's true, is it not, that on October 13th of 2008, you were contacted by Tom Bright in order for him to ascertain what your view was about the Preston employment dispute?
I didn't keep a calendar on that, but if that's reflected in Mr. Bright's calendar, I would take what he said to be true.
Well, Mr. Bright is going to testify next, but these are his notes from his telephone conversation with you. And they're dated October 13th of 2008, aren't they?
I just know that I talked to Mr. Bright on maybe 2 or 3 occasions, but I didn't make notes as what or when, except to say that when I contacted Mr. Bright to ask him after the second meeting that he had with the Personnel Committee, whether his opinion had changed any from the first time he met with Mr. With the committee, because at that committee meeting, the first committee meeting we had, he had indicated that the offer made didn't have merit. At the second, and I wanted to know, in talking with him, as to whether or not his opinion had changed.
Okay, let me turn your attention back to Defense Exhibit 22. And I have a question for you. Did you, or do you, deny that on October 13th of 2008, you told Bob Walter that, and I quote, 5 council members want to buy out his contract, end quote?
That I told that to Mr. Bright?
Yes. Do you admit that?
That might be true, because 5 council members did want to buy out his contract.
And you knew that as early as October 13th of 2008, right?
Not for sure, but I had every indication I think that they wanted to give Joey a parachute.
A parachute
A golden.
from your,
Yeah, golden
from your
parachute.
point of view, right? That's what you think.
That's my language.
And then, down below, these notes also reflect, in quotation marks, just cause, nothing concrete yet. And what I'd like to know is, do you deny that you told Mr. Bright in a telephone conversation on October 13th of 2008 that there was nothing concrete to support just cause of the termination of Mr. Preston?
At that point, I may have said that because we hadn't had an opportunity to fulfill our investigation about Mr. Preston's activities.
At that point, it's all I'm asking.
No, that's what I said then.
During your direct examination, do you recall the line of questioning about the retention of Mr. Bright?
The retention of Mr. Bright at the first meeting that we had?
Yes, sir. And during that line of questioning, what you said was the majority had the votes to get it done, right?
To appoint Mr. Bright?
Yes, sir.
Yes, I did.
You opposed it, but the majority had the votes, right?
Yeah, I was overruled, but I wouldn't have voted that way if I had known more about Mr. Bright. I just never met Mr. Bright, didn't know him, and it concerned me that the same crowd that was supporting Joey was asking to appoint Mr. Bright. That troubled me, and so that was the reason I voted against it.
The vote to hire Mr. Bright.
Right.
It was a 5-2 vote, wasn't it?
I think, we met in that room, and I just remember voting against it. That's all I can remember, because we were not in regular council. It looked like we were in some kind of committee room or something of that nature. So that's true. I voted against it.
The severance agreement vote was a vote of either 5-2 or
Right.
5-1-1, wasn't it?
That's right.
Because the majority had the votes, right?
They did.
You were in the minority.
That's correct.
Now, during your direct examination, you talked about instances where you attended personnel committee meetings. Do you remember that?
Something about personnel, yeah.
And there was testimony at length about how you were excluded from those personnel committee meetings. Remember that?
That's correct. I remember that.
At the time that those personnel committee meetings occurred, in October and November, it is true, is it not, that you were the defendant in a lawsuit that was filed by the county administrator?
The timing might be that.
The timing is in fact that.
Yeah, okay, well, if it is, I wouldn't argue with that.
Notwithstanding that lawsuit that was filed against you in your individual capacity.
That was the usual vote.
Notwithstanding that lawsuit filed against you in your individual capacity, you wanted to attend and participate in the personnel committee meetings that were discussing Mr. Preston's employment.
Mr. Davis.
Is that a yes or no?
Wait a minute, let me, can I answer?
Yeah, answer yes or no and then explain.
Okay. I wanted to find out what the recommendations were of the personnel and to know what was going on, because under our ordinance, we are encouraged to go to all committee meetings.
There were personnel committee meetings, right?
Any committee meeting.
I'm talking about these two. There were 2 personnel committee meetings about Joey Preston, right?
Right.
You attended them, right? During those 2 meetings,
I tried to get into the first one.
right?
And over the objection of Mr. Wilson, I think it was, I was able to attend because Mr. Greer read the statute the same way I did, and I was encouraged to attend. The second meeting I had, I think they changed their position and said I could not attend, and I intended to attend.
And my question is actually much more simple. During the pendency of both of those personnel committee meetings, you were the defendant in a lawsuit that was filed by
That's right.
Mr. Preston as a county administrator.
That's right.
Mr. Waldrop, can you turn the page and look at Defense Exhibit 48 for me? I see that. Mr. Waldrop, is this an email from Tom Beckwith to you?
Did I email him?
No. Is this an email from Tom Beckwith to you?
This looked like it was well, I see at the top, but it basically was an email to the editor of the Anderson Independent with a copy to me.
And it's dated October 13th of 2008, correct?
That's right.
And the very first line of this email from Mr. Beckwith with the albeit contained letter to the editor says, and I quote, "Recently I have been made aware of certain actions that the majority of the present Anderson County Council is considering taking involving certain council members and the county administrator," end quote. Do you see that?
Yeah.
And that is a reference to the severance agreement of
Right.
Mr. Preston, right? And so, as of October 13th of 2008, there's no secret going on. You knew exactly what the majority was planning on doing in relation to resolving this dispute. Right?
Mr. Davis, I have to respectfully disagree with knowing what a political body is going to do.
Okay. No problem. Let's keep going. If you don't mind, look at Defense Exhibit 118.
118. Exactly.
It's the
Is that the
one.
master employment agreement?
No, sir. Defense Exhibit 118 is the one that has handwritten notes. In the top hand corner is a 10, the date 10/27/08.
You want to help me out, show me, make
Yes,
sure
sir.
that I get
You may
the
approach
one that you're talking about. said one, I thought you said. Oh, okay.
My question about this document is simple. Does this reflect to you or refresh your recollection about the exact date on when the first personnel committee meeting occurred?
You know, it's a sketchy notes that apparently made by the chairman, I guess, of the committee.
Actually, these were made by Mr. Bryant. But,
Okay.
is this document dated, sir?
Oh, okay. I didn't know who made this. You know, it just speaks for itself. I don't know what to say about it.
Does this document reflect the date of October 27th of 2008?
It's dated.
Is that the date?
That's right. It has a date on it.
Can you turn and look at Plaintiff's Exhibit 22, which is the very next tab.
Okay.
Mr. Walter,
Yeah.
this is a letter from Rob Hoskins dated October 23rd of 2008, is it not?
Yes, it is.
You've seen this letter, right?
Let me take a look at it, make sure. I would say that I have.
This is a letter that contains a settlement offer, is
Yeah.
it not? And this letter is dated October 23rd of 2008, while the Personnel Committee notes reflect that that meeting occurred on October 27th of 2008, correct?
Right.
And during that meeting, you testified on direct that there was some conversation about a settlement demand made by Mr. Preston.
Yeah.
And this is that settlement demand.
Apparently.
And in this settlement demand made by Mr. Preston that was discussed during the meeting on October 27th that you can, it states, and I quote, "Per your request, I'm sending you Mr. Preston's proposal for a complete resolution of all claims against the county and the 2 individual council members we previously mentioned," end quote. Do you see that, sir?
I do.
Did I read that correctly?
Yeah.
Those 2 council members that are referenced in Plaintiff's Exhibit 22 are Sidney Wilson, yes,
That's right.
and yourself.
Right.
The very next sentence, sir, states, and I quote, "As you know, the scope of potential claims go beyond the 4 corners of Mr. Preston's employment contract with the county," end quote. As of October 23rd of 2008, or at least by October 27th of 2008, you understood, did you not, that Mr. Preston's claim was exceeding the 4 corners of his master employment agreement?
That's what he said.
You understood that's what the claim was, though, right?
I
I was saying whether it was true, I'm saying that's the claim. That was the claim, right?
He represented that to be true. Whether it was true or not, I don't know.
And down in the next paragraph, it states, and I quote, "Unfortunately, comma, there also exist a number of causes of action which Mr. Preston will assert against 2 current council members, as well as maybe 1 or more incoming council members," end quote. You see that?
Yeah.
And those 2 council members are you and Ms. Wilson.
Yeah.
Mr. Waldron, will you turn to Plaintiff Exhibit 7 for me?
Okay?
Is Plaintiff's Exhibit 7 the Preston severance agreement?
Yeah, November the 18th, 2008. Okay.
And this severance agreement, it's 4 pages long, right?
Right.
And this severance agreement is 19 paragraphs long, right?
Yes.
Will you look at paragraph 6 for me?
See it?
Does paragraph 6 state, and I quote, "In consideration of the county's agreement to provide employee with the severance payments described in this agreement, employee for himself, his heirs, his legal representatives, and his assigns hereby covenants irrevocably never to make any claim or demand, or to commence cause or permit to be instituted or prosecuted any suit, charge, proceeding, or action at law or in equity against the county of any of its council members, employees, managers, officers, board members, or any of its affiliated parts, entities, or subsidiaries, as well as the successors and assigns of those entities and persons by reason of any claim, demand, or cause of action which the employee may now have or may hereinafter acquire relating to his employment, ... End quote. Did I read that right?
That's what it said.
Mr. Waldron, did you cast a vote against the county executing this agreement?
I did.
Will you turn to Defense Exhibit 93 for me, sir? Mr. Walter, Defense Exhibit 93 is an email from anyone, is it not?
It is.
It's dated 11/13/2008.
That's correct.
The timestamp on Eddie Moore's email is 6:58 a.m., correct?
Wait a minute, I've got, see, this 92, I've got it from Annie Moore, and it's, the time I have is, 7:09 a.m. Is that?
Are you looking at Defense
I'm looking
Exhibit
at
93?
92?
93.
93, sir. 93.
3, oh, I'm sorry. Yeah. 6:58 a.m., right.
6:58. November 13th, right?
Yeah,
2008, right?
yes.
Who's Gail King? Gail King, who's Gail King?
From Gail King, yeah.
Yeah. No, it's to Gail King, but who is Gail King?
She works, I thought, in the, one of the finance areas of the county.
And you are blind copied on this email, are you not?
Yes, well, yeah, it looks like I was up here,
And it's timestamped 6:58 a.m.
right?
And down below, the email from Eddie says, and I quote, "Thanks for your quick response. We new council members just want to make sure no county documents are destroyed at all before our auditors examine them. You have a great weekend," end quote. Do you see that?
What it said.
And Tom Allen is also blind copied on this email, is he not?
I don't know if that's Tom's email. I see Thomas 9976. I don't know if that's Thomas Allen or not. It might be.
Okay.
But I don't know that.
Can you turn and look at Exhibit 92 for me?
Okay.
What I'd like you to do is turn your attention to the email at the very bottom of the chain.
Okay, what do you want from this?
I want you to turn your attention to the very bottom email. Can you do that for me?
Okay.
Okay. Is that an email from Eddie Moore to Joey Preston, dated November 13th of 2008, with a timestamp of 9:24 a.m.?
I have trouble reading these things sometimes, but I see this is November the 13th, 2008. I've got at 7:09 a.m. Is that what you have?
You may approach it with
Here, for a second. I'm talking about
Oh, no, I'm sorry.
Just
Okay.
Mr. Preston, and continues on the next page.
Oh, okay. Sorry, Mr. Davis, I just don't do email, and
I
this
understand.
is a
I-
very
Hard-
confusing communication to me, so that's why I'm having this problem.
And the email at the bottom of the chain is dated November 13th, 2008, with a timestamp of
Right,
9:24 a.m.
right.
And you are carbon copied on it, correct?
I see my name, yes.
And the council clerk, Linda Gilstrap, she's carbon copied too, right?
Yes,
And then that other email address, that Thomas 9976 email address, that's copied too, right?
yes.
At 9:24 on November 13th of 2008, does Mr. Moore write an email to Mr. Preston stating, and I quote, "I am respectfully asking that you hold off on doing any shredding of any kind of documents from Anderson County at the present time. We newly elected council members would like to examine any documents that are slated to be destroyed before this takes place." End quote. That's what that email says, right?
That's what it says.
Can you turn the page and look at Defense Exhibit 71 for me, sir?
Got it, I got you.
This is a letter dated November 17th of 2008, right?
Right,
This is a letter that's asking Mr. Preston to freeze hiring of 25 positions in the budget, correct?
that's correct.
You signed it, right?
I did,
Next to District 1 down there in the bottom.
yes,
Ms. Wilson signed it next to District 7 down there in the bottom, right?
right,
And then the 3 council members elect signed it. Mr. Moore next to District 3.
yes,
Mr. Dunn next to District 5.
that's correct,
Tom Allen next to District 4. Correct?
that's correct.
And the second sentence of this letter up above instructs Mr. Preston, and I quote, that this hiring freeze shall include the 25 positions provided for in our current FY 2008-2009 budget, which were to be funded after January 1, 2009. End quote. Right? Did I read that right?
I don't know if you did or not. What you did was, as I understood it, you said we directed him.
Yes, sir. You did.
That's not what the letter said.
Okay. Well, let's just get
The letter says, "We, the undersigned councilman and council on the list, ask that a hiring freeze be effective immediately."
And the next sentence says, this hiring freeze shall include. Does it not?
Okay, that's true, but we were,
And then down below, it carbon copies all media outlets. Does it not?
that's true.
So on November 17th of 2008, yourself and Ms. Wilson, who are on county council,
Right.
are sending out correspondence to the county administrator on county council letterhead, telling him what to do with respect to hiring.
Asking,
Asking.
not direct. We had no authority to do that.
Mr. Walter, what is your experience that the term shall means when used? Shall.
What shall?
Let's turn the page and look at the
Yeah,
next.
the word, it says hiring freeze, if he grants a request, it said shall include the 25 positions, but it doesn't say you shall do it. It says we're requesting that you do it, and if you do it, it shall include the 25 positions.
You had meetings in your office between June of 2008 and December 31st of 2008, did you not?
I think we've been over that,
I'm
yeah.
asking you a question, did you not?
Yeah, well,
Tom Allen attended those meetings, Tommy Dunn,
yeah.
Eddie Moore, Cindy Wilson, right?
Right.
In November of 2008, those 5 individuals are sending out correspondence on Anderson County letterhead, are they not?
They are.
Let's look at the next exhibit. Exhibit 49.
Is that 49?
Yes, sir. Mr. Walter,
Yes,
this is a letter
yes,
from Eddie Moore to the Attorney General of South Carolina. And it's dated November 25th, 2008, is it not?
it is.
As of November 25th of 2008, the county hadn't conducted the investigation that didn't commence until January of 2009, did it?
Okay.
That's true, right?
We have not been able to institute, we didn't have the mechanism in place to do anything.
Let me apologize. That question was confusing. Now, let me try it.
Thank you.
At some point, the county launched an investigation, correct?
Yeah, we did.
That didn't occur until after the new members came in January of 2009, right?
That's correct. We attempted to get information before that. I mean, Ms. Wilson and I did, but we were thwarted by the administration. So,
This letter is dated November 25th of 2008, right?
that's right.
And this letter is from Eddie Moore to Henry McMaster. And it's asking Mr. McMaster to start an investigation into Mr. Preston as early as November 25th of 2008.
Yes.
And on this email, or letter, this email, up above, you see the blind copy field.
Let me see. Yeah, I do.
And in that blind copy field, it's true, is it not? That WAIM radio's email address appears.
Right.
And that WAIM radio, that's Rick Driver, right?
Yes.
And also in that blind copy field, you see an email address that's southernboy@charternet. You see that?
Yes.
Do you know whose email that is?
Do I know who that
Do you know whose email that is?
is? Southern Boy?
Yes, sir.
It looks like it's an abbreviation. It's SUTH Boy. No, never heard of it.
Okay. How about the county clerk's email, she's blind copied, isn't she?
Yeah, I see that.
And up above, your copy and Mr. Allen's copy, correct? I'm sorry, you
See if
said
I
you didn't have
can
that.
read all this,
Your copy up above, right?
okay, yeah.
And then, in the third sentence of his email, Mr. Moore writes, and I quote, "The new majority of Anderson County Council, 5 members of the 7th, that takes office on January 1, 2009, would like your help with what happened at," I think it means hour, I think it's a typo, "at out meeting on November 16, 2009, end quote," which is also a typo because it should be November 18th of 2008. But the question I have for you is, as of November 25th of 2008, Mr. Moore has sent an email to the Attorney General asking him for his help, along with the majority of the county council, for January of 2009. And that's what that document reflects.
Yeah.
Mr. Moore, Mr. Walter, sorry. Can you turn to Defense Exhibit 50? Mr. Walker?
Yeah,
Are you at Defense Exhibit 50?
yeah, I'm on,
Oh, do you need more
I
time?
got you.
Mr. Waldrop, is this the order that was granted by Judge Nicholson on December 29th of 2008, wherein he granted an injunction against you from you, and that injunction was to enjoin you from interfering with the county administrator's duties any further? Correct?
That's correct.
In that first paragraph, second to last sentence, it reflects, and I quote, "A motion hearing was held at Anderson on Wednesday, September 24th of 2008, end quote." Do you see that?
What page are you on?
The first page.
Yes.
And September 24th, 2008 was actually the day just prior to when Anderson County received the letter from Mr. Hoskins putting the county on notice of his claims against the county. Was it not?
The dates coincide, the dates speak for themselves, I guess.
This order issues approximately 30 paragraphs or 31 paragraphs of factual findings against you and Ms. Wilson, does it not?
Yeah.
And in particular, paragraph 27 states, and I quote, "The county administrator's duty to supervise his employees is being intentionally and purposely thwarted by defendants," end quote. That's what Judge Nicholson found.
That's what it said.
Paragraph 29, second sentence. Judge Nicholson found, and I quote, "The actions of defendants have interfered with the county administrator's ability to do his job," end quote. Correct?
That's correct.
If you turn page 2 pages from there,
Which page?
2 more pages.
Okay.
May I approach you?
You may.
This one's actually a little harder to find, so.
We have the number. Okay.
2 pages later, below the block quote, and as the showing, to support a preliminary injunction, Judge Nicholson found, and I quote, that the plaintiff, Mr. Preston, has shown he is likely to prevail on the merits in this case. And
Right.
that's what he found, right? If you'll turn, sir, to the last page, or the last exhibit, which is Defense Exhibit 51. This exhibit reflects fees from the Richter Law Firm, correct?
Yeah,
And that's you. Those were your fees, were they not?
yeah,
And those fees were paid by the county, were they not?
it works.
And they were paid by the county because at some point the county council agreed that when you were doing the things reflected in Judge Nicholson's order, you were acting in your official capacity, right?
That's correct.
So the county agreed to pay your fees because in the instances of interference in that order, you were acting in your official capacity.
It works.
Ms. Walter, it's good to see you again. I wish I could have seen you under better circumstances. Thank you for your time.
Redirect.
Thank you, Your Honor. Mr. Lawrence, if you look at Defendant Exhibit 50, the one you just had a moment ago, the temporary injunction order,
Yeah,
was there ever a hearing on the merits in that case? They talked about a hearing on the merits.
yeah, there was no merit on the case because we were never afforded to put up a response to this case. Judge Nicholson had not terminated the case, but he had listened to the plaintiff's side, and we were never able, given an opportunity to respond.
The document in front of you, Defendant Exhibit 50, is a temporary injunction, is it not?
That's correct.
Was a permanent injunction ever issued?
No, I don't think he could do a permanent injunction.
And what happened with this particular lawsuit?
It was dismissed, the county dismissed it later on.
Thank you, that's all I have.
Your Honor, just one, more.
Isn't the reason, sir, that a permanent injunction was in fact not issued because when the new council took office in January of 2009, they instructed Michael Cunningham to dismiss that case?
Objection, Your Honor, calls for speculation as to what a permanent
As a
injunction.
member of council, he can say whether he knows. I don't know the answer to that question if he doesn't know. So I would ask the witness to answer of his own knowledge.
I think a request was made to Mr. Cunningham to dismiss this action, and then he declined to do so for a while. And then later on, he did comply with that request and dismissed the action against him and Ms. Wood.
Thank you for your time, sir.
Anything further?
No, Your Honor.
Sir, you may step down. Thank you very much.
I have to leave.
Sir, you wish to leave?
No, sir, I just said, do I have to leave?
Well, witnesses are sequestered, so you're going to have to step outside.
Your Honor, we were going to ask whether or not he can be released. I don't know. if you have a preference on that. We don't intend to call.
Excuse the witness from any further participation.
I'd be glad to excuse you, Mr. Walker.
All right, so you're excused. You can stay, but I will caution you will remain under the order not to discuss your testimony.
Not to say anything.
Yes. You can have a seat in the court. State may call us next week.
Anderson County calls Thomas Bright. I believe Mr. Bright is present.
Did you call Mr. Bright for me, sir? Thank you. forward and be sworn right here in front of you. Thank you, sir.
Would you raise your right hand? Do you solemnly swear affirm testimony you give the court today in this case to be the truth, the whole truth, and nothing but the truth? I do. If you would take a witness stand and state your name and spell your last name correctly, please. What's our steps, please?
My name is Tom Bright, B-R-I-G-H-T.
Mr. Gentry, your witness.
Thank you, Bob.
Yes, sir.
Good afternoon, Mr. Bright.
Gentry, how are you today?
I'm well, appreciate your time. Tell the court, if you would, what you do for a living.
I am a practicing attorney.
Where did you get your bachelor's degree?
I got my bachelor's degree from a small state school in Pennsylvania, Clarion State College.
When was that?
That would have been in 1978.
And where did you attend law school?
University of South Carolina.
When did you graduate?
I graduated in 1981.
All right, sir. Where are you currently employed?
I am employed by the Ogletree Deacons Law Firm in Greenville, South Carolina.
Are you a shareholder there?
Yes, I am.
How long have you been practicing with Ogletree?
I've been practicing with Ogletree probably for about 5 years, maybe 6. But I actually practiced with a predecessor firm that is now merged into Ogletree for about 23 years.
Does your practice have a particular focus?
I have practiced almost exclusively in the field of labor and employment law for the 31 years that I've been practicing.
All right. Have you had any involvement in the course of your career in the labor and employment section of the South Carolina bar?
Yes, I have. I've been a member. I was a member for a number of years and held several positions.
Were you president at one time?
I'm sure I worked my way up all the way through programs manager, through secretary, and eventually became the president of that section of the bar association.
Mr. Bright, do you recall being engaged in the fall of 2008 by Anderson County?
Yes, I do.
And are you able to testify today about that engagement?
As best I can remember, yes, I will.
All right. Is the attorney-client privilege a barrier to your testimony?
It is not in this case simply because the county at one point in time actually provided me with a written waiver of the attorney-client privilege, which would ordinarily prohibit or impede a lawyer from discussing anything that he had his retention by a client.
May I approach the witness?
You may.
Mr. Bright, I'm handing you what's been pre-admitted as Plaintiff's Exhibit 10. Do you recognize that as a copy of the waiver that you mentioned?
Yes, I do. This is it.
Thank you, sir. What, in general terms, was the nature of the engagement for Anderson County in 2008?
And I can't remember if it was early October, which I think is the time frame of 2008. One of my partners received a telephone call from the county. It involved Mr. Joey Preston and a letter that his lawyers had sent to the county, and we were retained to give the county advice with regard to that letter and the relationship with Mr. Preston.
May I approach the witness?
You may.
Mr. Bright, I'm now going to hand you what's been pre-admitted as Plaintiff's Exhibit 12. Ask you if you recognize that and can identify it.
This looks like the initial contact with our law firm through Buddy Daniel from the county council, and then it's also a letter to me saying that we have been retained.
And what's the date on the communication to you?
The communication to me from Mr. Thompson, who was the chairman at the time, was October 8th, 2008.
And is that consistent with your general recollection about the time that you first got involved?
Yes. Yes, it is.
Right. Let me ask you to look first at the message from Mr. Thompson to you. The first thing he does is wish you congratulations, which in hindsight is interesting. How does Mr. Thompson in the next paragraph characterize the claim that Joey Preston is making?
He characterizes it as a contractual claim.
Look, if you would, at the paragraph below that. What does Mr. Thompson say to you in this email about the desired timing of handling this matter?
He makes the point that there's only 4 meetings council left before the new council is to be seated. And he says time is of the essence.
The third and fourth pages of Exhibit 12 are a copy of the letter on Foster Law Firm letterhead dated September 25th, 2008. On the fourth page, it's signed by Rob Hoskins, and the letter has a number of addressees. Do you remember receiving this letter as part of the communication from Mr. Thompson?
I remember this as being a part of the initial contact with our law firm, yes.
What is this letter? Do you recall?
It is, and again, I can read it and tell you, I can tell you what my recollection was, is that Rob Hoskins was representing Mr. Preston at the time, who was the county administrator. I believe the letter reflects that several people had made some comments on the campaign trail that year who were running for county council.
Let me direct, I'm sorry, did you have?
That's all right, go ahead.
Let me direct your attention to the first 3 or 4 lines of the letter. There's a statement there from Mr. Hoskins regarding the time frame in which he says actions are expected to take place. What's his statement there?
It's basically saying that newly elected council members intend after January of 2009 to prevent Mr. Preston from carrying out his duties as the county administrator.
All right, if you look down about 4 lines from there, after talking about what Mr. Hoskins characterizes as attempts to hinder Mr. Preston's ability to perform his duties, there's a sentence that begins those attempts. Would you publish that sentence by reading it into the record?
Those attempts have, thus far, been most unfortunate for the people of Anderson County. But Mr. Preston has overcome the efforts of those who would stymie him in the performance of his duties.
Thank you, sir. In this letter, this September 25th letter from Mr. Hoskins to the members of County Council, is there any statement that the current council as a body had taken any adverse employment action against Mr. Preston?
The focus of the letter, and you can go down about 4 more lines, Mr. Preston considers the intent of certain members of council and their allies to prevent him from performing his jobs. And he looked at that as an anticipatory breach of his contract. But the focus is on the people that had been elected and would be coming into office.
So the expectation of what might happen in January 2009?
Just that they would do something to terminate his employment.
But there was no description of any current wrong by the current council?
Now, Rob Hoskins used the terms anticipatory breach, which means anticipating a breach of contract at some time in the future of his employment contract.
Do you recall, after receiving this email, Exhibit 12, from Mr. Thompson, when you first met with someone from the county?
I couldn't tell you what the date was. I could tell you that I most likely had a telephone call with someone from council, most likely Mr. Thompson. I know that the first meeting that I had was with Mr. Thompson.
And was that after the receipt?
Was after the receipt of this letter, yes.
Do you recall having a conversation with Mr. Hoskins in around this same time frame?
I'm sure I would have, because it would make sense that as someone that's been asked by Anderson County to respond to a letter that Mr. Hoskins had wrote. Mr. Hoskins and I live in the same town, we run in some of the same circles, he and I know each other. So it would have made sense for me to have called him as a courtesy to say that I was going to be involved.
Do you recall how Mr. Hoskins characterized generally what he was trying to accomplish with Mr. Preston?
I know that
You asking for what Mr. Hoskins said?
Yes, Your Honor. As he's a representative of the party opponent, it would be an admission of the party opponent through his attorney.
He's right about that.
I think he is right about that. You may proceed.
again, I don't remember the specifics. I do remember having reviewed my file at some point in time, that there is a handwritten note of my conversation with Mr. Hoskins, but quite frankly, I don't remember the specifics of what's on that note.
For the record, the parties have agreed that all of Mr. Bright's notes are pre-admitted. I'm not sure whether this one made it into that stack.
I understand.
So this is not marked, I'm going to show it to Mr. Bright.
You may approach with it.
Thank you.
Yes, sir.
Mr. Bright, is that your note, is the note you were referring to?
Yes, it is, and I specifically note, this is the way that I would typically make notes, is I would point out that I talked to someone who they were involved with or why I was making the note. It shows a date, which in this case is October 9th, 2008, and this is my handwriting.
Would you have made that contemporaneously with your conversation with Mr. Hoskins?
Absolutely, that's the way I typically do things.
And what does it indicate that Mr. Hoskins said to you?
He was telling me that during various press conferences that, and I can't remember if he said existing council members or newly elected council members, said that they would suspend Joey come January 1st. They will assign him tasks he cannot complete and ultimately terminate his employment.
And how did Mr. Hoskins characterize his goal for?
It was apparent to me from the very beginning that from his perspective, his client, because of the disruption within the county government and the newly elected people coming on board, that he was telling me, and these are the words that I use, that he knows he's finished and he needs to go out on his own terms. Now, I'm not sure that Mr. Hoskins said that exactly, but that is the impression I got. Those were my words.
And we will deal with admitting that appropriately if it's not marked.
Thank you.
Thank you.
Mr. Bright, do you recall what you did next in order to carry out your responsibilities to the county?
Well, as I said, one of the first things that I did was I met with Michael Thompson, who was at the time chairman of county council. I did several things, just kind of get a sense from him what was the scope of what he wanted me to do. And the scope of what he suggested to me is we need to find a way to have an amicable separation of Mr. Preston from the position of administrator. I wanted to make sure that Mr. Mitchell or that Mr. Thompson understood that I had done work for Anderson County before, so I shared that with him. And in fact had worked with Joey Preston, and he understood that. I also made it abundantly clear that I wanted to talk to every council member before I did anything, so I could just get some sense of what each of the council members were thinking.
Did you also perform legal research?
I'm sure at some point in time we did legal research because that's what this was about. This was about an employment contract. One of the questions I had in my mind was it enforceable? What were some of the legal issues associated with that? What are some of the practical issues associated with what they were trying to accomplish? So to tell you I did the research before I talked to people or after I talked to people, I can't tell you that. But yes, legal research would have been part of that process.
Did you read Mr. Preston's existing employment contract?
No doubt I read his contract probably more than once. Again, can I tell you when in this sequence of events I read it? No, but I certainly would have read it fairly early on.
Did you in fact talk to each member of county council?
Yes, sir, I did.
All right, and there are notes in the file that have been pre-admitted that reflect all of those.
Yeah, in fact, that's one of the things I did is to make sure that I had made notes of those conversations, which I did.
Do you have a general recollection as we sit here today of the impression that you came away from after completing this conversation?
It was clear to me that there were members of the sitting county council who were supporters of Joey Preston, who believed in Joey Preston. There were those who did not. I could, at that point in time, I could have identified who they were. But I think that there was a unanimous feel that this is not going to be a good situation. There was a need, and these are my terms, my words, for basically a divorce, and for him to leave county government and for the council to move on and find another county administrator.
Did you, at some point, Mr. Bright, ask for a calculation of the amount of severance that would have been due to Mr. Preston under his employment contract had he been terminated without cause?
Yeah, at some point in time, I believe that I made a contact through the then personnel office, through I think Phyllis McAllister, to contact the right person who would be able to look at his employment contract and be able to provide me with the various elements of what those pieces were worth.
May I approach the witness?
You may.
Mr. Bright, I'll show you what's been pre-admitted as Plaintiff's Exhibit 15. Do you recognize that?
Yes, I do.
What is that?
This is in fact a communication from Gina Humphreys to me saying here's the spreadsheet that entails the value of Mr. Preston's contract, and then the second page is an itemized listing of all the elements that were contained in that contract. And I'm not, that's basically what it is.
What's the date of the email from Ms. Humphreys to you?
October 17, 2008.
All right, and do you know what role Ms. Humphreys had in Anderson County?
I believe she was the head of finance, if I'm not mistaken.
Turning your attention to the second page, is it your understanding that this spreadsheet or this table on the second page is Ms. Humphrey's calculation of the aggregate value of the severance benefits under Mr. Preston's contract?
Yeah, in fact, it says summary of all compensation and benefits that would be expended either to administrator or on his behalf in the event of a contract termination without cause.
All right, and what is the total amount that Ms. Humphreys calculated?
The total at the bottom right was $827,222.
Did you at some point after that receive a demand letter from Rob Hoskins?
There was a detailed letter from Rob Hoskins. I couldn't tell you exactly what date. I want to say September 27th, but I'm not positive. That detailed not only, well, it detailed his position on behalf of his client, why he was asking for what he was asking for.
May I approach the witness?
You may. Excuse me.
Mr. Bright, I've handed you what's been pre-admitted as Plaintiff's Exhibit 22. Do you recognize that letter as Mr. Hoskins' demand letter that was sent to you?
Yes, and it's a little later than I thought. It's October 23rd, but yes, this is the one.
Is this letter the first dollar demand on behalf of Mr. Preston that you're aware of?
It's the first one that I can recall. That doesn't mean Rob Hoskins didn't say something to you earlier, but this is the first one that I recall.
Let me ask you first to look at the last sentence of the first paragraph. What's Mr. Hoskins conveying there?
It is consistent with Plaintiff's Exhibit number 15, in that he's reflecting that the value of his employment contract was $827,222.
And in fact, that's identical to the dollar to
Yes.
what Ms. Humphrey provided.
Yes, it is.
Was that all that Mr. Hoskins was demanding on behalf of Mr. Preston?
Again, I don't think there's clearly references to potential for other claims against individual council members. There's a request for retirement service credit. So there are additional dollar amounts.
Right, Mr. Bright, let me ask you to look at the first sentence of the second paragraph of this same letter there on the first page. Mr. Hoskins there refers to a number of causes of action which Mr. Preston will assert against 2 current council members as well as maybe 1 or more incoming council members.
Yes.
Do you recall that as Mr. Hoskins' justification for claiming more than the amount due under the contract?
Yes, and if you go on to the next sentence, he also talks about tort claims, given the extreme malice and intentional nature of the actions of the council over the past several years. I don't know that Rob ever articulated a specific tort claim, but it was clear that this was, in his mind and in the message he was conveying to me as counsel for the county, that this was more than a breach of contract.
And you anticipated to some extent the question I was going to ask you. This letter does not specify any particular tort claim.
No, it does not.
And I think you said you don't recall that Mr. Hoskins ever did specify a particular tort claim.
No, I don't remember. He may have, and I just don't remember it, but I don't have any specific recollection of that.
Was Mr. Hoskins asserting that Mr. Preston had tort claims against the county as an entity or only against individual council members and council members of that?
Again, when I read this letter, it talks about the individuals. I don't remember having any recollection that in his mind there was or in what he was conveying to me, that there was a difference between the two.
Were you being paid by the insurance reserve fund or by the county itself, to your knowledge?
I don't remember. I just don't remember.
Let me ask you.
I would suspect it was probably the county.
Let me ask you to look at the second page of this letter. The second paragraph details additional amounts that Mr. Hoskins says Mr. Preston needs, is the way he puts it. What are the additional amounts that Mr. Hoskins is claiming? Actually, the third paragraph is a better summary of all of the amounts, if I can direct your attention there.
I think there's a $356,087 through to purchase credits through the South Carolina retirement system, retiree health benefits of an additional $92,772.
And those are in addition to the $827,222 that have been calculated as the maximum amount available under the severance provision of employment.
Correct.
What is your recollection of how Mr. Hoskins explained that he arrived at the $356,087 retirement system credit payment?
I don't know how he calculated that number. I don't know where that came from. I do know that at one point in time, my office tried to contact, and did in fact contact, the South Carolina Retirement System, and in providing them with a scenario of someone with this number of years of service and trying to get this much credit, what would that cost be? And I know that we at least looked at that.
Was Mr. Hoskins' goal to allow Mr. Preston to retire immediately?
The goal was to have an immediate separation of his employment, and that he would, this would be an attempt in resolution of all his supposed claims, allow him to have that level of retirement and to leave the county.
And did you understand that that included his commencing to draw a pension immediately after the separation?
I don't remember that Rob and I ever discussed what, when, or if Mr. Preston would begin to draw anything. This was an attempt to try and put a value on what does it cost to get him to a place where he could.
Do you recall, Mr. Bright, how many times you met with the personnel committee of the Anderson County Council?
I know I met at least twice with the personnel committee.
Were both of those meetings after your receipt of this October 23rd letter?
I have to believe that the answer to that question is yes, because there wouldn't have been anything to discuss with them until we had this demand.
Mr. Davis just showed Mr. Walters a moment ago a document that suggested, I think it was one of your notes, that suggested the first meeting was October 27th, 2008. Is that consistent with your recollection?
Yes, it is.
At that meeting, what advice did you give to the personnel committee?
Well, by that point in time, as I told you, I couldn't remember when we did research and when I talked to all the individual council members, but by that point in time, I would have done my legal research. I would have had a conversation with Rob Hoskins. I would have had the letter from October 23rd with his various demands. And I would have talked to each of the council members. At that point in time, I had 2 or 3 things that I felt I needed to convey to the personnel committee. The first of those was that Rob Hoskins had in his initial letter of September 25th, and then again in the letter of October 23rd, was claiming that his client was being constructively discharged. For lack of a better term, that's the creation of intolerable working conditions that forces someone out of their job. I made the observation to the personnel committee that I didn't see anything that suggested anything of the sort, and therefore I didn't think much of a claim of constructive discharge. I also made the observation that because the consternation seemed to be between the newly elected council members and Mr. Preston, one of the recommendations I made is that they not do anything right now. That they allow the new city council to deal with the issue of Mr. Preston. Have Mr. Preston go about his job, do what he'd been hired to do, and let the new council deal with it. The third thing that I tried to share with the council was that there was a long line of cases in the state of South Carolina that suggested that his employment contract in the first place was void or voidable. In other words, they didn't have to pay him this money. He didn't have a 3-year contract as you and I would think of it. And I made that very clear to them. But at the same time, as any good lawyer does, I made sure that they understood, but you never know when you get in the courtroom what's going to happen. And so I shared with them what I felt might be some of the worst case scenarios if Mr. Preston were to sue the county and if Mr. Preston were able to prevail. So I shared that whole panoply of thoughts that I had about how to handle this whole process.
Mr. Bright, you mentioned or you testified that you advised the committee specifically on the claim of constructive discharge. Did you separately analyze and provide advice on a claim of anticipatory breach?
Yeah, I mean, to me, the concept of either constructive discharge or anticipatory breach went hand in hand in my legal thinking whether something had been done that would suggest a breach in the future, or whether something had already been done. I didn't think either of those things had happened, and so I didn't give much credence to those claims at that time.
We also talked about Mr. Hoskins' claim of unspecified torts. Did you place additional value on those purported tort claims?
Again, I think that in trying to convey to the Personnel Committee, again, what a good lawyer does is he doesn't make decisions for his clients. He lays out all the facts and allows them to make choices. And I wanted to make sure they had a full understanding of what all the possible ramifications were for this particular contract and for the claims that Mr. Preston was raising.
Did you tell the committee that you had concerns about their own personal liability potential?
One of the last things that I made sure that the council was aware of, and I'm not sure exactly how I put this, but I said to them, and this really kind of goes hand in hand with telling them to leave it for the new council, is I made the comment that I said, I can't tell you right now that I know of any theory of law which would support a lawsuit against the individual council members if they were to make a decision to give Joey the kind of money that he was asking for in these letters. But that I had a concern that that is something that could happen in the future. In fact, it became a matter of dialogue between Mr. Hoskins and myself, because he wrote me a letter at some point in time saying he can't think of any theory like that either. But I was concerned that at some point in time, a taxpayer within the county might say to the city and council members, you gave our money away and you shouldn't have done that. And I said I couldn't come up with a theory, but I was concerned about that issue.
Did that concern arise in part out of the fact that, as you put it, you didn't think much of the anticipatory breach and constructive discharge?
I don't know that I necessarily connected those two thoughts. I think my thought was, in the grand scheme of things, the picture was, as I said, a divorce and a payment of a lot of money to one person for that divorce. And I was concerned that after the fact, that if somebody felt this was not a proper action for the board or the council to have taken, especially in light of my research that I've done on the contract claims, the Coward claims, that someone might pursue a cause of action against those councilmen.
Mr. Bright, you said that you tried to sketch a worst case scenario for the committee. Is that accurate?
Yes.
What did you tell them about the worst case?
Well, what we talked about is we obviously talked about the allegations in the October 23rd letter. There was a contract claim. There were potential for tort claims, wrongful discharge, those types of things. And what I tried to share with them is, okay, if you were to lose, here's what the contract's worth. Here's what the litigation costs could be going forward. There's always the potential if he's going to raise tort claims for compensatory and punitive damages. And so we would have discussed the fact that if Armageddon were to occur, this could certainly clear $2 million in exposure for the county.
Was that Armageddon number intended by you to be a valuation case?
No, sir. I was not trying to tell them that I thought they were on the hook for a $2 million. But as a good lawyer, I was trying to say that's always a possibility. It was not done on my part to parcel out each element of the claims and add them up and say, here's the exposure. I was merely trying to give them a big picture. He's certainly claiming this much for breach of contract. If he's claiming more for tort claims, if there's your expense costs and everything else, you could be talking in excess of $2 million.
So you started with his $1.2 million approximately demand.
The components of that, yes, and worked our way up from there.
Without factoring in any analysis of the likelihood of recovery.
This was not a function of suggesting to them the likelihood of recovery. It was merely expressing to them that this is a possibility. And in fact, I would suggest to you that I made it abundantly clear that I felt that the contract claim, in light of the research that I had done, was highly questionable.
At that first meeting on October 27th, did the committee give you any instructions or have any reaction for you at that time?
No, in fact, I can remember leaving, and I was impressed by the fact that it wasn't just the personnel committee. I had been instructed to deal with the personnel committee. That's the way we want you to communicate with the council. But I was impressed by the fact that Mr. Waldrop came, I believe Cindy Wilson came to that meeting, neither of whom were members of the personnel committee. And it, as the lawyer giving advice to the entire council and to the county, I was encouraged by the fact that they were there. But at the end of the meeting, I left thinking, I don't know what's going to happen next.
Was there then a second meeting?
There was a second meeting.
Between the two meetings, did your view of the merits of Mr. Preston's claim change?
No.
What do you recall about the discussion at the second meeting?
It was very much akin to the first meeting that we had, in that I was again reiterating the various five or six points that I laid out here a few minutes ago. And again, it was at that point in time that I was going to, they basically gave me my marching orders on what to do next.
And what were those marching orders?
The marching orders were that we appreciate what you've told us. We've taken that into consideration. We've decided that it's best for the county that Mr. Preston no longer be the county administrator, that we end this chapter, that's my words, not theirs, end this chapter in county history and move on. So Mr. Bright, we direct you to go and talk to Mr. Hoskins and try and get the best deal you can.
But did you understand that your assignment was to settle the matter?
Resolve it, that he was no longer going to work there. They were going to pay him some amount, and I was to find out what that amount was going to be.
Yeah, go ahead.
You may.
Mr. Bright, Plaintiff's Exhibit 24, also pre-admitted, appear to be your notes of the November 10th, 2008 meeting. It says meeting with Joey Preston, but it appears that Rob Hoskins, Candy Kern Fuller were there representing Mr. Preston, and you were there with Ellis Fisher from your office. Is that correct?
That's correct.
What do you recall about that meeting?
This was a meeting that was scheduled for Rob Hoskins' office. The point was to try and have a discussion about trying to have a resolution to separate Mr. Preston from the payroll, to find basically work out a severance agreement to end the relationship.
Was Gina Humphreys present at that meeting?
Yes, she was.
How did she come to be there?
I have no idea.
You didn't ask her to come?
No, sir, I did not.
And I think you testified previously that your involvement with Ms. Humphreys was that you received her calculation of the severance benefit.
Correct.
What was your reaction to her presence there?
It was troubling to me in the sense that, and again, you have to understand the mindset that I come from, representing management in these kinds of relationships, is that she was a member of the management team. I didn't invite her to be there. I was surprised she was there. When I got there, I believe she was in the conference room with Rob Hoskins and Joey Preston, and that troubled me. I know I discussed it with either Mr. Wilson or maybe several of the members of the committee, saying, I don't understand this. But I don't think I really did anything about it other than express my surprise. It was disconcerting that she was there.
Was she there supporting Mr. Preston in terms of financial calculations?
That was the conclusion that I reached.
She hasn't laid a foundation. We know that.
call for speculation at this point in time, if you can lay a foundation for his knowledge of why she was there.
Did Ms. Humphreys, to your knowledge, provide calculations to Mr. Hoskins or Mr. Preston or his team?
The only thing I can tell you is that I was provided by Mr. Hoskins with a spreadsheet that was very similar to what you handed me as plaintiff's exhibit number 15, except that it had a few more notations added to it, and I want to say the numbers went as high as $1.3 million. So the conclusion that I reached is that she had provided that to Mr. Preston.
In the course of this November 10th meeting, did Mr. Hoskins reiterate the demand that he had made in his October 23rd letter?
Again, and I can't remember the specifics, but my general recollection was something in the vicinity of $1.3 million was his demand. And the other thing I think it's important to understand is that at the point in time that I went into those meetings with Rob Hoskins, I made it abundantly clear to him, as I had to the council members that I was dealing with, that they had nothing in particular to offer to Mr. Preston. In other words, county government can only act in an open session of their meetings. So they hadn't gotten all the council members together to say, what do we want to do with Joey Preston? This was the personnel committee exploring possibilities and asking me to find out from Mr. Hoskins and from Mr. Preston what their offer to the county would be. And that was the approach that I took to the entire process.
So you had to go to Mr. Hoskins and say to him, in effect, would you take any less than what you've asked?
Well, when I had those discussions with him, yes.
Did that put you in a little bit of a negotiating disadvantage?
I would say a little bit, yes.
Did Mr. Hoskins, on behalf of Mr. Preston, move down much in his demand in the course of this November 10th meeting?
I don't know that it was in that meeting or if it was in subsequent conversations and phone calls we had later, but eventually the number came down to 1.1. And again, that's not an exact number, but it's round figures.
Let me direct your attention, Mr. Bright, to the second page of this Exhibit 24, the last line. After the November 10th meeting was over, did you make a report back to the Personnel Committee?
Yes, and I don't, in fact, this reflects that I talked to Mr. Wilson, I talked to Mr. McAbee, and I had left a message for Mr. Greer. So those were the three gentlemen on the Personnel Committee that I was reporting to. So I tried to keep them up to date on what had happened in that meeting.
What did Mr. McAbee say in response to
Now, again, I don't remember the specific call. I can tell you these are my notes. This is my handwritten notes from November 10th, and it reflects that he said to go ahead and give him the $1.3 million.
Well, Mr. McAbee, based on that, was prepared to settle at that level?
Yes.
Does that suggest that the $1.1 million number was arrived at sometime after this?
And then there's no, it's clear that it was.
After November 10th, did you talk to Mr. Wilson and get some more specific guidance from him on a target number?
I would have had to. I don't have a recollection. I know that I would have made notes of that in my file if I had. But most definitely I would have talked to him after that meeting. I didn't just leave it at one phone call.
Do you recall when your recollection of the $1.1 million number is in fact roughly consistent with what's in the severance agreement? Do you know when that number was arrived at?
I can tell you that, and I want to say that somewhere either on the 17th or the 18th, we were exchanging drafts of a proposed settlement agreement. So the number would have had to have been arrived at between November 10th and either the 17th or the 18th. I don't think it would have been as late as the 18th. It would have had to have been before that. And again, understand, that the way I postured this all along with Rob Hoskins is, Rob, this has to come as an offer from you. We talked about ballparks, we talked about possibilities, and what is something that the committee felt they could put before council to be accepted. So these were numbers that were always coming from Rob Hoskins as an offer to the council, and that's the way I presented it.
But you had guidance from the committee?
Absolutely, absolutely.
Was Mr. Wilson, as chairman of the personnel committee, the primary person involved in giving you that guidance?
Yes, it was.
At the time that the $1.1 roughly $1 million number was being arrived at, were you asked by anyone on county council for your assessment of whether paying $1.1 million to settle these particular claims was a good use of county money?
No one asked me that question.
Did you have such an assessment?
I wouldn't have done it if it were me. But that was based on the research that I had done and shared with the county, that in fact, I didn't think this was an enforceable contract.
Did you take were you primarily the drafter of the severance agreement?
I told Rob that I had, and again, most law offices have these, some form of a template that you use for severance agreements and the like, with things that we have tried over the years and been proven successful and permissible. So that's what I did. I took the major responsibility for drafting the agreement.
The severance agreement has been admitted, and I can certainly put it in front of you if it would be helpful to you in answering this question. But my question to you is with regard to the provision of the severance agreement, which is a covenant by the county not to sue Mr. Preston. And specifically, did you have any discussion with Mr. Hoskins about whether that language should be drafted to prevent a suit like this one challenging the validity of the severance agreement?
We never had that discussion, no.
When you were drafting, was that question in your contemplation?
That was not something we were contemplating. Again, what we were contemplating was a no-fault divorce that was basically going to say, in exchange for this amount of money, you're not going to work there anymore. And the parties are not going to have anything to do with each other.
Can I approach the witness?
You may.
Mr. Bright, Plaintiff's Exhibit 26 has also been pre-admitted. It appears to be an email from Rob Hoskins to you dated November 17, 2008. Do you recognize that?
I sure do.
If you would look at the fourth and fifth lines, Mr. Hoskins writes, although I know that the agreement needs to be voted on tomorrow night, and that the substantive figures are what is being considered, there are a few legal issues with regard to the final settlement agreement that I need to obtain consultation on. Did I read that correctly?
Yes, you did.
At least by November 17th, were you aware that there was a plan to vote on the severance agreement on November 18th?
I knew that the objective was to try and have the details worked out so that the matter could be presented to the full council on the evening of the 18th.
Did Mr. Wilson give you any instructions about whether or not you should come to that November 18th council meeting?
I know that he and I talked about it, and I offered, I said I'd be more than happy to be there. If you think that might help, if people have questions, you can certainly go into executive session of the council to have them ask me questions about any of the legal issues that are involved. Part of that was predicated on my concerns that they were paying this kind of money when I felt that there was a contract that might not be enforceable. But he said there's no need for you to do that. And so I did not attend.
Thank you, sir. Please answer any questions, Mr. Davidson.
Davis, before you get that, we're going to take about a 5-minute break. I'll caution the witness not to discuss your testimony during the break with anyone. So we'll be in recess for about 5 minutes. Thank you very much.
Yeah. why.
Good to meet you.
You turn it on and
Let's see, Mr. Davis, there you are. You ready to proceed?
I am, Your Honor.
All right, you may do so.
Your Honor, may I approach?
You may.
Ms. Bright, did you meet with the attorneys for the county to prepare for your testimony today?
I have had several telephone calls with them, and I think I met with them one day last week before my deposition.
And how many telephone calls have you had since your deposition?
2, and there may have been an email message or 2 just telling me when to be available.
And how long did those telephone conversations last?
Relatively short. I think the longest one was probably 40 minutes.
Did you discuss your testimony today?
We discussed the facts as I know them.
Mr. Bright, you referenced on direct examination an instance when you previously represented Anderson County. Remember that?
Yes, it is.
One of those cases was the Jackie Hunter case, wasn't
Yes,
it?
it is.
Jackie Hunter case was a case that went to trial, right?
Yes, it is.
Jackie Hunter case was a case where you gave advice to the county that they had a really great defense in the Jackie Hunter case, right?
I'm sure we did.
You went to trial,
Correct.
you lost.
I think we did.
You lost a several $100,000 verdict.
I believe so.
The county paid for all your attorney's fees and the judgment, right?
Yes.
Many of the council members who were on the county council in 2008 were on county council when you represented them in the Jackie Hunter case. Was they not?
I don't know.
Larry Greer was on it?
I don't know.
Larry Greer, he was on the personnel committee?
Yes, he was.
Now, you told the county in this case they had a good defense too, right?
I don't think I was discussing with them a defense. I told them I did not think that the contract was enforceable.
And you cited a long history of
Yes.
South Carolina precedent.
They're very old cases on this point,
Long history.
but they go back a long ways.
Newman versus McCullough. That's the
I
Seminole
know.
case, right?
I don't remember what the Seminole case is.
Coward v. Ford, that's the next one, right?
That's one I remember.
After Coward v. Ford, there was the case down in Beaufort Jasper.
I remember a Beaufort County case, yes.
During your deposition, I asked you what the exception was to that rule. Remember that?
I think that's how you characterized it, yes.
And you told me you didn't know what the exception is.
I think my answer to you was, I'm not sure that I'd call it an exception. I remember discussing with county council that there was something in the enabling legislation that would allow, under certain circumstances, for the county to enter into a contract for a term of years.
And in fact, in the decision of Coward v. Ford, one of the things that they said was if there is a specific enabling statute that prescribes legislative authority with respect to a term of contract, you can do it, right?
I'm not here to interpret the law
Oh,
as the Supreme Court interprets it. I'm here to tell you what my conclusions were based on the law as it was presented to me. The
You're
facts
only-
as they were presented.
You're only here to testify that you provided advice that the contract was unenforceable.
No, I didn't provide advice that it was unenforceable. I said I had strong questions about the enforceability of the contract, and I still maintain it today.
Well, now, Mr. Bright, out of fairness to me, on direct examination, you got up and you suggested that you told them that this was an unenforceable contract,
Well, I
right?
didn't. You didn't listen to me.
Oh.
I told them that I had a real strong concern about the enforceability of the contract. If you have to read the record back, I think you can see that that's exactly what I said.
All right, well, let me ask you about your real strong concern. In relation to forming that real strong concern, Mr. Bright, did you take into consideration the exception that was outlined in the case of Coward v. Ford?
Again, you characterized it as an exception. I remember that there's something in the enabling legislation that said that there is a possibility that a contract for a term of years might be something that is outside of that general proposition. But I also believe that there's case law that talks about the fact that those can be reconciled.
Can you turn to defense exhibit number 35?
I assume it's in this booklet.
Yes, sir.
All right, I've got it.
And all I'd like to know is, by scanning this decision, does this look like an opinion that you would have had in your file and how you would have marked it up?
Yes, it is. It's the Coward decision.
Can
Yeah.
you turn to defense exhibit 36, which should be right after that?
I've got it.
And this is part of the enabling legislation that relates to the employment and qualifications of an administrator, is it not?
I believe it is.
And it reflects South Carolina Code 4-9-620.
Yes, sir.
And this is how you would mark up that statute as it appeared in your file.
Again, it looks like this is the way I would have highlighted something as I read through it.
Man, sorry to flip around on you, but you're a little bit more versatile, a witness for exhibits. If you could look at defense exhibit 16, which should be the very first exhibit.
Yes, I've got it.
Defense exhibit 16 is an outline, or more correctly, a timeline of events during your representation, is it not?
Yes, it is.
You wrote this document?
Yes, I did.
You're sent to the Anderson County Council.
I believe we did, yes.
Now, I'm kind of interested in something, Mr. Brown. If you had any inkling, that there was fraudulent conduct going on with respect to Mr. Preston's severance agreement, would you have pushed forward with representation, sir?
Judge,
I'm not sure what you're asking me.
If during your representation you learned facts that caused you to believe that the execution of the severance agreement was in some way fraudulent, would you have persisted in representation?
I doubt that I would have, no.
You doubt, or you absolutely would not?
I'm sure that in any situation where there's a possibility that someone has committed fraud, I will not say categorically one way or the other that I'm going to pass judgment on that on a hypothetical that you present me. I can tell you this, I have been in the courtroom before where a witness has testified falsely and has committed perjury. And as a result of that, I took my responsibility and oath that I took 31 years ago and that you've taken the same one. And I took it very seriously. I took it to the Supreme Court, I took it to the Court of Appeals, I took it to the client, and we exposed that that's what was going on. There was false testimony in a trial. And so if you're asking me whether I would have the integrity to report something that was fraudulent, yes, sir, I would.
Mr. Bright, I have no idea what you're talking about. What I was trying to ascertain was, if during this process, the contract negotiation, you learned that it was somehow a fraudulent deed, that it was a put-up job, a sham, as the county's alleging, you would have quit, right? You wouldn't have participated.
I would have explored the issue as I just explained the way I've handled it before, and I would have done the appropriate thing that my oath requires me to do, and that the disciplinary rules that you and I are under would require me to do.
You wouldn't have participated in what you perceived as a potential fraud.
Absolutely not.
Absolutely. And in this case, that didn't happen, right?
What case? You mean, did anybody tell me that?
You were representing the county in relation to Joey Preston 7th Street. You didn't throw up a flag and say, whoa, whoa, I'm out of this. I'm not going to represent the county in relation to this deal if there's something wrong. That never happened, right?
Yeah, what are you talking about? Are you talking about fraud or something that's wrong?
Fraud.
Which fraud? No one expressed anything that suggested fraud to me.
Mr. Bright, on direct examination, you testified about how you informed the personnel committee about a potential downside risk of about $2 million. Remember that?
Again, I think what I should have said is, it wouldn't have surprised me that I used an analysis that may have suggested $2 million. I don't remember saying that, but that would not have surprised me. I would have outlined for them what that risk was.
Because I asked you about that just about a week and a half ago, right?
I believe so.
And at that time, you told me you didn't really remember exactly, but it didn't surprise you.
That's right.
Can you turn for me to Plaintiff's Exhibit 3? On direct examination, you were asked questions about how the anticipatory breach or constructive discharge would occur until January 1st of 2009. Do you remember that?
I don't think I said January 1st, 2009. I think we talked about anticipatory breach and that sort of thing. Yes, I remember that.
Do you remember the whole line of questioning about the new council coming in? And
Correct.
Those are the ones that they were really concerned about. It was in the future. Do you remember that?
Yes.
And the new council came in January of 09, right?
Okay.
About halfway down, the middle of paragraph, or Plaintiff's Exhibit 3, paragraph in the main body, there's a sentence that states, and I quote, certain council members have hindered Mr. Preston's ability to perform his duties as county administrator for at least 7 years now. Those attempts have, thus far, been most unfortunate for the people of Anderson County, end quote. Right?
Yes, you've read that correctly.
Those aren't attempts to hinder Mr. Preston that are occurring in the future, right?
This sentence doesn't reflect that, no.
And in that exact letter, they're referencing attempts to hinder Mr. Preston's ability to do his job now and in the past.
That's the language that's used in this letter.
It's true, is it not, that you didn't conduct a factual investigation into the validity of Mr. Preston's claims?
What were his claims? Tell me what claims you're talking about, and I'll try and answer that as best I can.
Okay, well, he had claims, remember, for anticipatory breach.
Yes.
and claims for constructive discharge.
Yes,
And then we looked at a letter from October to 23rd, 2008 that reflected potential tort claims.
correct.
It's true, is it not, that you didn't conduct an investigation into the facts supporting those claims?
I did not go out and try and interview individuals to find out whether or not there were tort claims that existed. Rob Hoskins didn't share any of those with me specifically. So no, I didn't conduct an independent investigation of those things. That wasn't what I was asked to do.
In fact, when I asked you this a week and a half ago, your answer was none whatsoever. Was it not?
That's exactly right. That's what I'm telling you today.
Can you turn to Defense Exhibit 17 for me? The first question I have for you, that's your handwriting, right?
Yes, it is.
Those are your notes.
Yes, they are.
Those are notes that you take either contemporaneously when you're on the phone with someone, or
Correct.
when you're meeting with them.
Correct.
You don't intentionally put incorrect facts in your notes, right?
I put information in my notes that people are informing me of. So whether they're accurate or not, I don't know. I'm merely I'm putting down what people are telling me.
Your intent is to capture what they're telling you
Yes.
accurately and correctly.
Yes.
In Defense Exhibit 17, do you see in the upper left-hand corner, it says 5 for Joey, 2 against Joey?
Yes.
And this memorandum was something that you wrote when I don't have any video. You can leave the lights on. This was a memorandum that you wrote right after you were first retained, correct?
It reflects my notes the very moment that we were retained. Now, whether or not this was Buddy Daniel, my partner, who was sharing this with me, or whether it was Mr. Thompson over the phone, I don't remember that. But I do remember this was the first note that I made of any information that I had.
And down in the middle of the page, it says, and I quote, WAIM-AM, 1230, Rick Driver, rumor, arrow, second set of books, end quote.
Yes.
Right? And someone was telling you at that point in time that this radio station, WAIM, was reporting a rumor about Mr. Preston.
Yeah, I believe that's what it was, yes.
And the rumor apparently was that there was some sort of second set of books.
Yes.
At some point, Mr. Bright, did you become aware that Mr. Preston had sued in his official capacity to sitting county council members?
Someone shared that with me. Did I ever verify it? No, but someone shared that with me, yes.
And the facts and circumstances relating to a suit like that, those would be facts and circumstances that you might like to know when offering opinions about someone's employment claims.
No,
None.
no.
Did you ever come to learn, Mr. Bright, that the court, in the case that Mr. Preston actually filed against Ms. Wilson and Mr. Walter, actually issued a preliminary injunction against them?
Someone told me that, but I don't specifically remember digging into that. Someone may have told me that. I may have looked at something that said that, but that's not something that's in my memory today.
And would it be an important fact if Anderson County took the position that Mr. Walter, for example, was acting in his official capacity when found to have been interfering with Mr. Preston's contract?
I wasn't asked to evaluate whether anybody was interfering with Mr. Preston's contract. I was asked here's a demand from his lawyer that says he wants to leave and he wants this money. Will you please evaluate that for us and give us your best advice? And that's what I did. I wasn't asked to look into the background of Mr. Preston. I wasn't asked to look into any allegations that anybody was making about Mr. Preston. That wasn't what I was asked to do.
On October 23rd of 2008, you received a letter from Rob Hoskins.
I'm sure that's the right date.
And that letter stated in it that Mr. Preston's claims exceeded the four corners of his master employment agreement.
I went over it a few moments ago and I read different parts of it. My position was he was making claims that went beyond just a contract claim. That he specifically was identifying tort claims against individual council members. And again, whether it was in my conversations with Rob Hoskins, he was reflecting wrongful discharge and any number of other types of claims. Yes, I thought it was more than a contract claim that he was articulating.
You thought it was more than a contract claim also because the October 23rd, 2008 correspondence says that his claims do in fact exceed the four corners of the contract, does it not?
Again, I think that's what I said earlier, and I think I referred to the second paragraph in the letter, and the second page of the letter, several paragraphs in there.
And those claims included tort claims, did they not?
Yes, specifically, I never knew the content of what those tort claims were, but they were, the way the letter put it was tort claims against several of the council members and newly elected council.
When providing advice about potential liability with respect to Mr. Preston's claims, did you ever study and research the Tort Claims Act?
I've studied the Tort Claims Act on many occasions.
And what does the Tort Claims Act say when there's instances where an individual is named, a government individual is named in their personal capacity?
Be more specific. What are you looking for?
The truth. Does
You
it not-
suggest that I would offer anything else than that?
No, it would.
I would be highly offended that somebody that I practice law with would say that. But go ahead.
Mr. Wright, it was a joke.
And I didn't find it very funny.
Well, let's move on.
Does the Tort Claims Act not, in fact, require the substitution of the government entity when individuals are named in lawsuits?
The Tort Claims Act is very detailed. And certainly one of the aspects of the Tort Claims Act is when a tort claim is brought against an individual, in appropriate circumstances, the entity becomes the defendant. There are other circumstances where the individual can be sued in their individual capacity.
And in fact, if the person were acting in their official capacity, or the county, for example, in this instance, acknowledged they were acting in their official capacity, it would require the substitution of the county, wouldn't it?
I think by operation of the law that happens. I don't think that there's any, if a lawsuit gets filed and it has 5 or 6 different names attached to it, I don't think they are automatically eliminated from the caption of pleading and the entity is inserted. I think that's an operation by law. That's something that happens by operation of law. Who's going to be held responsible for it?
In fact, there's a statute that provides for that, correct?
Could be.
And there's an opinion. I think it's the flat toe opinion.
I'm not familiar with it.
Did you make any efforts to obtain the pleadings from the lawsuit where Mr. Preston sued Bob Aldrich, the person he was in?
I don't remember doing that, no.
Will you turn to Defense Exhibit 18? And the very first thing that I need to ask you is, up in the top left-hand corner, I can't quite read your handwriting. What does that little note say?
Which one? The one on the upper right, left-hand corner?
Yeah, the very top one of that.
I can't tell. Something but won't say so, and I don't know.
Okay.
What exhibit are you looking at now? I was typing, I missed the number.
Defense Exhibit 18.
Thank you.
October, does this exhibit reflect your notes from October 9th?
Yes, sir.
And that was a meeting with Michael Thompson.
Yes, sir.
And to your knowledge, was Michael Thompson the chairman of the county council?
That was my understanding.
And is it also your knowledge that the chairman of county council constitutes an ex officio member of every subcommittee?
Didn't know that, no.
Didn't know that?
No.
Down towards the very bottom, there's one straggly line, and then right above it, there's 4 lines that begins with Preston. Do you see that? Preston has sued.
Yes.
It says, quote, Preston has sued Waldrop and Wilson for interfering with Preston's job, went into finance office with Channel 7 demanding certain financial records, end quote.
Yes.
What do you remember about that?
I obviously had to have been told that in this meeting by Mr. Thompson, but I don't have any specific recollection of that.
Do you recall that Mr. Waldrop and Ms. Wilson actually went into the finance department with the news crew?
I have no idea.
Would that have been something you'd like to know when you were providing advice?
In terms of the job that I was asked to do and what I was asked to look at, no.
On direct examination, I thought I understood your testimony to be that the amounts underneath Mr. Preston's severance agreement were way too high. Is that incorrect?
No, I think what I said is I wouldn't have agreed to it.
You wouldn't have agreed to it.
No, sir.
It would have been contrary to what you advised the county.
I didn't advise the county. I gave the county, as a good lawyer does, an understanding of what the options were and the upside and the downside of those options for them to make a choice and a decision on what they wanted to do.
And the potential downside, you don't deny, was communicated as potentially exceeding $2 million.
Absolutely.
Right above that passage we just read, Mr. Bryant, does it reflect that Michael Thompson told you as of October 9th, 2008, while he was the county council chairman, that when, quote, when new council members are seated, there will be changes, end quote?
Where are you reading now?
May I approach the witness?
You may.
Sorry, I did that out of order.
Again, I don't have a specific recollection of that being said, but obviously I wouldn't have written it in my notes if someone hadn't said that to me. So it was Mr. Thompson.
Yeah, and these are your
Absolutely.
notes from your meeting with Mr. Thompson.
In my handwriting.
I was going to ask you that next. If you turn the page and look down, there's a passage in the very middle that says, and I quote, Bob plus Cindy, arrow, opposed to hiring anyone. He presented, end quotation mark. Do you see that?
Yes, I do.
And was it your understanding from your meeting with Mr. Thompson that Ms. Wilson and Mr. Waldrop were actually opposed to your retention?
Even sitting here reading that today, I don't have that recollection. It doesn't say that. It says we're opposed to hiring anyone. I don't know who that anyone refers to. So no, I can't agree with your statement.
And then down below that, it reflects, and I quote, 5 others looked at it, decided to hire us after executive session, made a vote 5-2, end quote.
That seems to suggest that I was making notes about retaining the law firm that I work for.
And The ultimate severance agreement, though, it was 5-2 or 5-1-1?
I have no idea.
You don't even know that?
No one asked me that question. I didn't.
I'm asking.
I don't know. I never did know. In fact, I take that back. I'm sure someone may have told me, but I don't have any kind of recollection.
Will you turn the page and look at the next passage? Does that reflect on the first real line? And I quote that 3 auditing firms have said clean, end quote.
Yeah, if somebody would have had to tell me that. I assume it was Mr. Thompson.
And actually, I made a knucklehead mistake when I was talking to Mr. Walter. But did you ever find out that Anderson County, as of 2008, had had 11 clean audits that mirrored every single year that Mr. Preston worked during this account?
No one ever shared that with me, no.
No one ever told you that.
Right.
If you look down, there's one sentence there. It's under, see where the number 21st appears?
Okay.
Now, I thought you said under rags that you told Mr. Thompson that you insisted on interviewing every single councilman.
I did.
And your notes reflect that Mr. Thompson told you that he wanted you to contact each council member and let them tell you their side of the story.
He may have said that as well.
Mr. Thompson told you to call all the council members and find out what the position was, did he not?
That's what my notes reflect. I also specifically remember that's something I wanted to do. And I told him I was going to do.
In your conversation with Mr. Thompson, you found that Mr. Thompson believed that it was important for you to find facts and opinions that were believed by all the other county council members that were sitting at that time.
He didn't give me any guidance on what he wanted me to ask them. I wanted to be comfortable that each one of them had an understanding of what my role was, what my job was, what I was being retained to do, and I wanted to hear from them.
Now, Mr. Bryan, when a layman tells you, and I quote, let them tell you their side of the story, end quote, what do you normally perceive that to mean?
Tell you whatever they want to tell you.
About Mr. Preston's employment situation.
I didn't try to characterize it as anything in particular. That's obviously what I've been retained to handle.
Let's look at the next exhibit. That's exhibit 19. Is there a, if you turn to page 3 of this exhibit, there's a paragraph in the middle that refers to Bob Walker. And I guess I should clarify. These are your notes from either a conversation on telephone or in person with Tom Martin.
Yes,
Tom Martin was the county attorney.
yes, he was an attorney at McNair, if I remember correctly.
Page 3 of this exhibit discusses what Mr. Martin told you about Bob Walker, right? And what Mr. Martin told you about Bob Walker was that, 1, he ran for the state legislature, he was a good reformer, but now he's a changed man. He hates Tom and he hates Joey. And he feels that Joey's not forthcoming, right? That's what Tom Martin told, right?
Correct. That's, again, I wouldn't have written that down if that's not what he told me.
down below, in the very bottom, Tom Martin also told you, and I quote, Joey is seeking injunctive relief to enjoin them, and it notes up above, Cindy and Bob, from interfering with his job. Buddy Nicholson, end quote. And Buddy Nicholson was the judge, right?
That was my understanding.
If you turn the page, there's another passage. And it refers to a lawsuit that Joey brought. And it says, and I quote, Joey sued Cindy for invasion of privacy, error, settled, open for end, running registration of his BMW, end quotation. Tom Martin also told you about the potential problem in the relationship between Cindy Wilson and Mr. Preston, right?
I'm sure I knew that at some point in time. Whether or not it was Tom Martin who told me that, I'm not sure I can remember.
Now, did you do any investigation into what the dispute was between Ms. Wilson and Mr. Preston?
No, there's no need for me to do that.
Can you turn to Defense Exhibit 20? Defense Exhibit 20 are notes from a telephone conversation that you had with Ron Wilson on October 13th of 2008.
That's right.
And that's still right in that initial time frame when you were first retained.
Correct.
In the middle of the page, there's a section that talks about Bob Waldrop. And it says, and I quote, Waldrop allied with Cindy. His daughter applied for a job at McNair, turned down, Waldrop upset, end quotation mark. Do you see that?
Yes, I do.
At some point in time, did you become aware of the fact that McNair was fired as the county attorney?
I knew that at some point in time. When, I don't remember.
If you turn to the top of page 2, and there's a passage, and it says, and I quote, spend whatever to make sure they know where all the money is, end quote. Do you see that?
Yes?
Can you ascertain from your notes who that statement is attributed to?
Again, it's part of my notes of my conversation with Ron Wilson. Whether he's saying that or someone else has said that, it's information he's conveying to me.
Okay. At the very bottom of the page, there's a passage, and it says, and I quote, he's heard her say, let's fire him, end quote. You see that?
Yes, I do.
And when Ron Wilson told you that, he was attributing that statement to Cindy Wilson, wasn't it?
I don't have,
This is one of the passages we were talking about, which as far as state of mind, Mr. White, what he was informed is fine, but it is obvious hearsay within hearsay.
It's been pre-admitted. I don't understand what the objection is.
The objection is as to the use of it for the truth of the matter asserted that it was William's statement. Mr. Bright had it before him.
Now, wait a minute, Judge. We had a deal. All the notes were coming in, and they've been pre-admitted. When it hurt me, and they were stuffing into that invite, I didn't object because they were pre-admitted. But now, he doesn't like it.
This has been put into the record, it's an exhibit, is that right?
That's correct, Your Honor. My point is just the scope for which it may be used.
Overruled. You may proceed.
Mr. Wright, it's true, is it not, that on October 13th of 2008, Mr. Wilson was talking to you on the phone, and he indicated to you on the phone that he had heard Cindy Wilson say that she, what, you heard Cindy Wilson say, let's fire.
Again, that is I don't know who's referring to. I don't remember a lot of the conversations specifically. That makes sense, but I don't know what her refers to specifically. That certainly makes sense to me.
Well, let me ask you this, Mr. Wright. On county council in 2008, in the employment dispute came up, how many women were on county council?
I don't have any recollection.
Were there two?
I don't know.
Was
I
one,
do know there were two. I don't know whether there were more.
Was one Gracie Floyd?
Yes, I believe so.
Was one Cindy Wilson?
Yes, I believe so.
If you could rule out Gracie Floyd, could you reasonably conclude it was Cindy Wilson?
Again, I don't know. I don't have an independent recollection sitting here today of him saying that he heard somebody say, let's fire her. Obviously, you told me that because it's in my notes, but I don't know who her refers to. It could have been somebody in the public. That doesn't make sense to me, but I don't remember. What does make sense is that it was Cindy Wilson he was referring to.
Right above it, it says, and I quote, easiest way out is to buy him out, end quote. Does it not?
Yes, it is.
And Ron Wilson was telling you, as early as October 13th of 2008, that it was, in his opinion, the easiest way out of this mess, right?
Yes.
And on direct examination, you testified about how the political climate had deteriorated in this time frame, right?
That was my understanding, yes.
And your understanding was further that Mr. Preston was the lightning rod at the center of that, right?
I would certainly agree with that.
And what Mr. Wilson is telling you is that the easiest way out of this mess is to buy the guy out and send him on his way.
Correct.
An amicable divorce.
Correct.
You turn and look at the next exhibit, Defense Exhibit 21. Mr. Bryant, are these your notes from October 13th of 2008 from a telephone conversation you had with Larry Greer?
Yes.
Larry Greer was on the Personnel Committee.
Yes.
And Mr. Greer's conclusion, as reflected in the last sentence on the bottom of Defense Exhibit 21, was, and I quote, a buyout is cheaper than protracted litigation, end quote.
Yes.
That was his conclusion, right?
That was his conclusion then and throughout the process of my dealing with him.
And in fact, that has borne out to be true, right?
I have no idea.
1.1 is less than 2.5. Can we agree to that?
Objection, no foundation.
Mrs. Bryant?
I'll ask you to rephrase.
I'll do that. I should probably let you realize. I'm sorry.
Thank you, sir.
Mr. Bryant, did you ever learn how much today the county has spent investigating Mr. Preston and our lawsuits?
No.
Can we agree that when a county council member makes decisions that impact her or his constituents, they have to take into consideration more than maybe just a lawyer does, right?
I've never run for public office, so I have no idea what they take into consideration.
Well, you represented the county in this instance, didn't you?
Yes, I did.
And in this instance, these representatives have to take into broader consideration things that may impact the best interests of the county, right?
I'm sure they do. There's no question in my mind. That's what I would do if I were in public office.
And those things don't stack up in a neat little 1, 2, 3 column that allows you to calculate a specific number.
Yeah, You're asking me something I'm not familiar with, so I would say, no, it doesn't.
You don't know.
Correct. Correct.
Can you turn the folder to Defense Exhibit number 22, is this correct? Ms. Wright, these are your notes in the telephone conversation that you had with Bob Walter on October 13, 2008. Isn't that correct?
Yes, they are.
And the second sentence states, and I quote, 5 council members want to buy out his contract, end quote, right?
Yes.
And Bob Waldrop told you on October 13, 2008, that 5 council members wanted to buy out Jody Preston's contract.
I'm sure that's what he told me, because that's what I wrote down. Yes.
Mr. Waldrop knew that all the way back in October 13, 2008, right?
Again, I can only tell you what he told me.
Down below, it says just cause in quotation marks. You see that?
Yes.
And it says just cause, arrow, and I quote, nothing concrete yet, end quote. Right?
Correct.
Mr. Waldrop told you as of October 13, 2008, in your telephone conversation, that there was nothing concrete to support a just cause termination. Right?
I'm sure that's what we were talking about, and I'm sure it's what he told me.
Mr. Bright, when you were rendering your opinions about the enforceability of Mr. Preston's contract, did you take into consideration when the budget ordinance is passed funding that contract?
We didn't discuss it, no, and I did not research it, no.
So you don't have any idea how that might impact the enforceability of the contract, do you?
No.
Will you turn to Defense Exhibit 23 for me? Now, in comparison to what Mr. Waldrop told you, if you look down, it looks like Ms. Wilson told you, and I quote, there's a strong possibility of cause for discharge, end quote, end quote.
Again, because I wrote it down, that must be what she told me.
And you had that conversation with Ms. Wilson on October 13th, 2008. Is that right?
Correct.
And it was by telephone.
I believe so.
Down in the middle of the page, there's a sentence that begins, the lame ducks. Do you see that?
Yes, I do.
And it says, and I quote, the lame ducks want to buy out the administrator, put new administrator in place, end quote. Do you see that?
I sure do.
As of October 13th of 2008, it's true, is it not, that Ms. Wilson communicated to you on the telephone that the lame ducks, who were the majority of council at the time, wanted to buy out Mr. Preston's contract?
Again, that's what she told me. I can't tell you what she believed or didn't believe. I can only tell you what she told me.
This wasn't something that sprung up on November 18th of 2008, was it? The 2 minority members knew it in October, right?
What's your question?
The two minority members on council knew this in October, right?
Knew what?
That the majority was looking to buy out Mr. Preston's contract.
Again, I can only tell you what was shared with me, and what was shared with me is the lame ducks want to buy out the administrator's contract.
And then down at the bottom of the page again, it says again, I quote, 5 council members looking to buy out contract.
Yes,
End quote, right?
yes.
Turn the page and look at Defense Exhibit 24. Are these the notes from your conversation with Councilman Bill McAfee on October 14th of 2008?
Yes,
Mr. McAfee, he's on the personnel committee, right?
yes, it was.
down the middle of the page, he is indicating to you where the bad blood with Cindy Wilson came from, does it not? All related to Beaver Dam sewer line.
That is what he shared with me, yes.
And what Mr. McAfee shared with you on October 14th of 2008 was, and I quote, "This is payback for her," end quote. Right?
Yes.
Down below, Mr. McAfee says, and I quote, "Her allegations are unfounded." Right? End quote.
That's what he told me, that's what I wrote down.
Now, Mr. Bright, will you turn to Plaintiff's Exhibit 15 for me? And if you could turn to page, and I guess just for purposes of the record, Plaintiff's Exhibit 15, that's an email from Gina Humphreys to you dated October 17th of 2008, right?
Yes.
And you asked Gina Humphreys to do this, didn't you?
Yes, and again, I think, if I remember correctly, the original request was made through Phyllis McAllister, who I was much more familiar with in the Human Resource Office. I may have talked to Gina directly, I just don't have a recollection of that.
And in fact, your billing records actually reflect conversations that you would have with Ms. Humphreys, do they not?
I haven't looked at the billing records, so I don't know.
You don't deny that,
I don't know.
right? Which means you don't deny it, right?
It means I don't know.
Let's turn to page 2. Mr. Bright, can you look at line 3 for me and tell me how that number was calculated?
No?
Mr. Bright, can you look at line 5 for me and tell me how that number was calculated?
No?
Can you look at line 6 for me and tell me how that number was looked?
No?
And how about 7?
I don't know how any of these numbers are calculated.
You don't know how any of these numbers are calculated, right?
Correct?
And you were surprised then when the person who actually calculated the numbers attended the meeting where the settlement negotiations occurred between the parties.
Yes.
Mr. Bright, can you skip over to Defense Exhibit 25 for me? Now, Exhibit 25 has 2 passages in it I'd like to ask you about.
Okay.
First one is in the first line. It says, and I quote, "At Waldrop campaign event, Arrow made clear they will assign Preston tasks he cannot perform, will run him out," end quote. You see that?
I do.
And that was what Mr. Thompson was communicating to you in October 21st of 2008.
Yes, it is.
And then down in the next little paragraph, and it says, and I quote, "Original and corrected transcripts, Arrow said, quote, suspension," end quote, in original, end quotation mark. What is your recollection about what that passage is referring to?
I remember there being, I can't remember if it was a subcommittee of the council, and there was a transcript of people who said things during that committee meeting, and I remember that it related to that, but beyond that, I don't remember anything specific.
Are you referring to the August 5th subcommittee meeting of Finance Committee?
It may be, I don't know. I know I looked at those minutes at one point in time.
And in fact, the minutes that you looked at didn't have a certification of their authenticity on it.
I don't remember. they did or not.
Mr. Fry, I have one quick question for you about Plaintiff's Exhibit 22, which will be the next exhibit in your packet. And my question for you is this, and if it helps you, perhaps you might like to look back to your timeline that we put on the very first exhibit. But at the Personnel Committee meeting, it's reflected as having occurred on October 27th of 2008, where Ms. Wilson and Mr. Waldrop also attended. Did you communicate to that Personnel Committee the contents of this October 23rd, 2008 settlement offer?
I can't imagine that that subject didn't come up.
Because lawyers have to communicate settlement offers, right?
Well, I would have done it, so yes. I can't imagine it didn't come up, but I don't remember handing them a copy of that.
Now, that settlement offer is dated October 23rd of 2008, correct?
Correct.
Now, if you look at the next exhibit, Plaintiff's Exhibit 29. That's a memorandum dated November 3rd, 2008, right? And it reflects that Mr. Greer, from District Number 3, called to request about certain information in the general fund, right?
I've never seen this before. I don't know.
The question I have for you, though, is it consistent with your recollection that after you got the demand from Mr. Preston's attorneys, that what the Personnel Committee would have done next was to look and see what monies it had available to negotiate the dispute with him?
I have no idea what they did after that. That's a lot of logical sense, but I have no idea.
But they would have to know what they had on hand to be able to spend.
I have no idea what they have to know. I know that would make sense to me. I
You
didn't
don't
ask
think
them to
that
do
the
it.
Personnel Committee would need to know what funds the county had available to it in order to settle with Mr. Preston, in order to actually settle?
I have no idea what they did or did not do, or had to know, or I didn't have to know. I know it makes sense to me that they would do that, but I have no idea whether they did or not.
And if you look at Plaintiff's Exhibit 31, and this was the memorandum from Gina Humphreys to Ron Wilson.
I've never seen this before.
And in it, she specifies an amount, right? Down there in the second paragraph, short answer, I believe the county will have sufficient budgeted funds to cover the amount that's in discussion, right?
Again,
That's what it says.
What it says.
And-
I've never seen it.
And on November 4th of 2008, the county had the benefit of Mr. Preston's settlement demand dated October 23rd of 2008, right?
Assume so.
You turn to Defense Exhibit 26. And this, Mr. Bryant, I believe, are your notes from the November 4th, 2008 Personnel Committee.
That's what it looks like to me.
And there's a section that's labeled Ron Wilson. And under that section, it reflects that, and I quote, "This controversy ongoing for several years wants to find the quickest way to get it over with," end quote.
Right.
And isn't it true, Ms. Bryant, that when you were polling the county council members, with, save two, the other five uniformly communicated that sentiment to you. This has been going on for years. We need to get this over with.
First off, I never did a polling of county council, number one.
Well,
Number two,
okay.
let me finish my question, or my answer. Number two, there were three people that expressed to me that this controversy had been ongoing, or that I recall expressing this feeling. And that is Mr. Wilson, Mr. McAfee, and Mr. Greer. I specifically remember them telling me that this controversy, meaning Joey Preston, had been going years.
In my
I may have gotten that reaction in some respect from Mr. Waldrop. I don't remember Ms. Wilson. The others I don't have a distinct recollection of.
Okay, fair enough. But we looked at some notes from Mr.
Sure.
Thompson, and Mr. Thompson was telling you the same thing. This has gotten out of control, right?
I don't remember what they said from the 30 minutes ago that we looked at it.
Now, I don't understand your testimony here today to mean that you're trying to second guess the council members' decisions with respect to such issues, right?
My testimony here is to merely answer y'all's questions. I don't have a position.
So the answer is, that's correct.
I don't know if that's the right answer to your question or not. I can only tell you that my position here today is to tell you what happened, not to take a position. I don't have a position.
Down below, in Defense Exhibit 26, under Greer, it says, and I quote, "Time for him to go, but make it an equitable solution," end quote, right?
Correct.
And then if you turn the page, there's a specific passage in your handwriting. It says, and I quote, "Get Gina, call to get the limits," end quote, right?
Yes.
Gina was your numbers girl.
Well, it was the person I was referred to get the numbers, yes.
Gina was not only the person that you referred to, she was actually the department head, was she not?
See, my understanding, she was finance director.
There's nobody above her in the finance department, right?
I don't believe so.
Gina Humphrey, she's a CPA, right?
I don't remember.
Will you turn the page, Mr. Bright? And again, your notes state, and I quote, "Meeting held, arrow, they would give him something to do that he could not perform, and that he would be fired for insubordination," end quote.
I see that now.
And that was something that you were again told on November 4th of 2008.
I can only assume so because it's attached to and appears to be a part of the notes from that day.
That wouldn't have been something you would have put in there on your own, right?
No, absolutely not.
Mr. Broad, if you look at Defense Exhibit 28 for me. It's broken down by sections, right?
Yes, it is.
Section 2, that's a section about legal analysis, right?
Yes, it is.
And under legal analysis, you go through anticipatory breach, and you go through constructive discharge, and you go through no resignation, and then you say what you do going forward to create that situation. But can we agree, Mr. Bright, that under legal analysis, there's no section that addresses the potential tort liability?
I don't believe there is, no.
And in order to address the potential tort liability, it's true, is it not, Mr. Bright, that you would need to do an investigation of the underlying facts?
I would think that would be true.
Davis, we're about 15 minutes past 5. I don't know how much longer the cross is going to be. If you're going through all of these tabs, I expect it to be a long.
Well,
Correct.
the upside, Your Honor, is,
And I'm not trying to cut you off, it's just that,
I think one of them is a big, thick one.
yeah, so it sounds like to me we'd be better served to come back tomorrow.
Your Honor, if I may,
Yes, sir.
I'm scheduled to leave at 7 o'clock in the morning to go to Tryon, Georgia. And I don't have a choice in the matter. I've got a client training session that begins
Well, this is a non-jury hearing. I'll be glad to suspend this testimony and give you a chance to finish your cross-examination at a later time.
I'll make a deal with you, Your Honor.
I'll go to 5:30 if you'll finish by 5:30.
If you give me until 5:30.
I don't know about these gentlemen on redirect. They've got a right to redirect.
Yeah, that's right, I can't make the
Can't
deal.
speak for them, so,
As of right now, I'd like about 2 minutes.
2 minutes, but I'll give you the 5:28.
Well, that's only because
I apologize if that creates a problem.
I understand. Well, like I say, if we have to come back on another day, I can do that.
Well, if it suits you the same, Ron, I'll just try to go ahead and get done at 15 minutes.
I was hoping to, that's the reason I let you go past 5 o'clock, but now that we're getting, and I'm looking at the length of numbers of tabs here, and that was the reason I was thinking this may go on for some time, so let's try to get it wrapped up then.
Mr. Bright, informing your opinions that were communicated to Anderson County Personnel Committee, did you take into account any information about meetings that may have been held at Mr. Waltrip's office in the summer of 2008?
No.
If you turn the page to page 2, there's a section that's called contract delivery.
Yes.
And specifically, I'm interested in number 2. And it says, and I quote, appointment and removal of chief executive is a governmental function, end quote. You see that?
Yes, I do.
In fact, that's the analysis that the Coward theory is bottom line, isn't it?
Yes, I do.
The reason why you can't bind successive county councils unless there's a legislative hearing is because the hiring and firing of administrator is a governmental function, right?
Correct.
And one council can't bind the ability of the next council's ability to exercise discretion about that authority.
Correct.
Can you turn to page 3 for me, Mr. Bryan? There's a section that says value to contract demand, and then there's a section that says B1 cause. And what I'd like to know is that 3A, that's referring to the section of the contract that's termination for cause. Is that right?
I would suspect that's true. That's typically the way I would do that.
And in order to terminate somebody under the contract for cause, and the contract being the master employment agreement, there would have to be a conviction of a crime of personal gain or moral turpitude in your analysis.
Right, and now that you've shown that to me, it refreshes my memory on something you asked me earlier today, when we were talking about termination for cause. Termination for cause, in many circumstances, has a generic, it's a generic term for do you have any reason to terminate. Termination for cause in the context of this contract means those specific 3 provisions.
Exactly.
So that may have been a disconnect between a question you asked me and an answer I gave you.
You see that? We're building bridges. Under your
They
recommendations.
won't be long enough, Council.
Under section 6, there's a section called recommendation. Do you see that?
Yes, I do.
And it says A, B, C, D, E, F, and G, right?
Yes.
And that's not meant to be a singular recommendation. That's meant to be different options, isn't it?
Yes, it is.
And for example, one of the things you say is, well, you can write back a letter and say there is no anticipatory breach. And then if you go down to letter F, you say settle with him without his contract, right?
Yes.
And one of the options that you identified for them was you can settle and buy this contract.
Yes. I think that whole section is consistent with my prior testimony.
Okay. You can turn to Exhibit 27 for me. What I'd simply like to know in relation to this is, these are your notes from your telephone conversation with Ron Wilson on November 11th, 2008, correct?
Yes.
And if you look in the second page of that, at the top, there's little lines, sort of, I don't want to call it bullet points, call it something else, a line, I guess. And it says, and I quote, full release of county and council members, end quote, right? And in fact, it's true, isn't it, that under the master employment agreement, it doesn't require a release of the council members, it only requires a release of the county, right?
Well, again, you have to understand that what I was dealing with was creating a separate contract that would provide X compensation to Mr. Preston in exchange for a release. I was not trying to do something that mirror imaged the employment contract. So this may be consistent with or more than or less than the employment contract. I don't know. We were trying to structure a complete agreement.
Turn to Plaintiff's Exhibit 1 for me, and let's look at that real quick.
Exhibit what?
1.
Got it.
Turn to page 4. If you put your finger back on page 3, section 3B, that starts on section 3, is a section about termination without cause, correct?
Yes.
And underneath that section, there's a section, subsection, letter E, right?
Yes.
And under letter E, it says, and I quote, contemporaneously with the delivery of all severance pay and entitlements herein above set out, the administrator agrees to execute and deliver to the county a release, releasing the county of all further claims that the administrator may have against the county, end quote, right?
Correct.
Where in that paragraph does it use the term council members?
I don't see it in there.
Doesn't appear, right?
No.
So the severance agreement, by contrast, which is the loose document that I have for you, and I lost mine, so I'll have to-
Plaintiff's Exhibit number 7.
I believe that's correct, Tom, but I truly don't have it in front of me.
My copy indicates so.
Under Plaintiff 7, paragraph 6 is the section where Mr. Preston is releasing claims. Isn't it?
Yes.
And under that section, it's not limited to just the county. It also includes everything against the county of any of its council members, employees, managers, officers, board members, or any of its affiliated parts, entities, or subsidiaries, as well as the successors and assigns of those entities and persons by reason of any claim, on and on and on, right?
Yes.
And that's broader, is it not, than the master employment agreement?
Again, I think these two documents serve different purposes. So I will agree with you that one is broader than the other. They don't serve the same purpose.
The severance agreement's release is broader than what's required under the master employment agreement, section 3, subsection 2, subsection E.
Again, I would agree with you, but I would point out that I think they're comparing apples and oranges.
I know that's what you do, but I just want to know the answer to that question.
Yes.
Paragraph 34, Mr. Bryant.
Are you mean defendant's number 34?
Yes, that's what I
Okay.
mean. This is the opinion of Cindy Wilson versus Jody Preston, right?
Yes,
Went all the way up to the Supreme Court, right?
yes,
Decided in June of 2008. Yes?
yes.
Turn to page 5 of that opinion. In the middle of the page, it reflects that all the way back in 2005, during her deposition, that Ms. Wilson had already received, and I quote, 59,000 pages of documents from the administrator. End quote. Do you see that?
Where are you referring to? Page 5? Yes, I see it. Yes.
That's all I wanted to ask you about.
I don't know whether it's true or not.
Well, it's in a Supreme Court opinion, right? If you look back at Defense Exhibit 31, actually, if you do me a favor, if you go to Defense Exhibit 30 real quick, I have one question for you about that.
This is going to be your last set of questions.
I have 3 minutes. All right, on November 18th, 2008, you sent a letter to Ralph Hoskins.
Yes.
And in the very bottom of that paragraph, it references a $24,000 Social Security issue. You see that?
Yes.
And basically, you're writing there that, hey, listen, I don't understand this, and you don't understand that, right?
I didn't understand it, don't today, no.
All right, if you turn to 31, does 31 reflect a finalized settlement agreement that you sent to Ron Wilson on November 18th?
I know it was the last revision, I shouldn't say that. It's what I viewed as the final version of the settlement agreement.
And on November 18th of 2008, you sent the last draft as of 4:54 p.m.
Yes.
Right? And that was literally 1 hour and 6 minutes before the county council meeting started.
I had no idea.
So when the county council members said they had never seen this before, that was true, wasn't it?
I don't know if the council members have said that, and I don't know whether it's true.
In Defense Exhibit 33, real quickly, in the very middle of it, there's a letter. Let me just show it to you. I may approach you, right?
You may.
This is a letter from Rob Hoskins to Tom Bradley. It's dated October 27th of 2008.
You say exhibit number 33?
Yes.
What's the date of the letter? 23rd?
27th. I just looked at mine. So I wanted to ask you, is this letter from October 27th, 2008
Okay.
to you from Rob Hoskins?
Yes.
It specifically addresses or talks about that issue relating to the exception to code about which we talked about.
Yes.
Mr. Bright, I sense from you that I may have asked an inartful question that caused you to think I was asking something that I wasn't. If that happened and it upset you, I give you my sincere apologies. I thank you for your time, and it's good to see you.
Yes, sir. Jenny.
Mr. Bright,
Yes.
were you asked by Anderson County Council for any advice or opinion on whether certain members of county council should or should not have voted on Mr. Preston's severance?
No.
In your file, when there's an indication that you have highlighted portions of a statute or a case, does that mean that you read only the highlighted portion?
Oh, no. It's typically what I will do is I'll read an entire document, and things that either are extremely important to me at that time, or something I may want to remember, or maybe I want to refer back to, I will typically highlight, but I'll read the whole thing.
Thank you. No further questions.
Thank you. All right, we're going to recess at this time. We'll resume in the morning. Any problems starting at 9 o'clock?
No, Your Honor, may we excuse this witness from the trial?
Any objection?
No, Your Honor, you can see
Ms. Reed, you make your point.
Thank you.
All right, any problem at 9 o'clock in the morning?
No, sir.
All right. 9 o'clock, we're in recess until that time. Thank you very much.
No, I don't think so.
It's not as comfortable as they look. First 30 minutes.
I'm gonna tell you, they're a lot more comfortable with us.
You're right about that. I've sat nose to
This job okay?
Yeah, it's about the first 30 minutes, it's all right. After that, numbness starts to set in.